Just waiting for the printer. Yeah, they were. Yeah. Oh. Good afternoon, everyone. I hope you all are doing all right and everybody's doing okay. It's been a very rather interesting day today. But it's so hot. Unbelievably hot. Lord have mercy. I don't even think it gets this hot in Gambia. It is so hot. It's unbearable. Trust me. Anyways, I'm just waiting for more people to join the Facebook Live, and I'm also printing the ruling of the High Court with regards to the DNA testing, and then we'll get on. So basically what we saw today in Gambia, quite honestly, was unprecedented. Never in the history of Gambia has there been a situation of one accused person in a matter that is not politically motivated, has no semblance of politics in it, and to see people from all walks of life. I mean, there were young people, I saw older people. I mean, just the background, the crowd was just diverse. This was not just young people, so you can't say it was just the youths that were coming out. There were people that left their offices, people that left their jobs. Even in the uniform men, the uniform police officers that were there, you could tell that. I mean, just the way, and this is something I want to commend, the way and manner by which the police have conducted themselves today, dealing with such a crowd, with emotions being very high, and the police were able to contain supporters of whatever part of the divide that they were. But the police really, to be honest, did very well, and they must be commended in the way and manner by which the crowd was controlled. I didn't see them harassing anyone. I didn't see them taking advantage over people. And I think this was commendable. So really, if you look at this matter and look at what is going on in the Gambia, quite honestly, I mean, you don't have to like Bob. You don't have to like the alleged victim in this matter. It just divides. I mean, there's a unanimous call for a fair, effective, sincere, and open dispensation of justice in this matter. I think that is the substantive call. Remember, this matter has been in court for quite a while, and it didn't generate such public condemnation and outcry as to the manner by which everything is being conducted. However, Gambians have been taken for a ride for far too long. And mostly people think that Gambians, the average Gambians, especially the authorities and people, the powers that be, people that are within the corridors of power, there's this tendency to feel that, Gambians are very gullible people, and that Gambians don't understand, and Gambians lack the wherewithal to understand complex matters and complex issues. But this is false. This is not true. It is just that Gambians are normally, ordinarily, very tolerant people. They are very slow to react. But once they do, it's like a tsunami because you can't stop them. And what is happening with regards to this Bob matter is a revolution that is being born in the Gambia. And the authorities, especially the executive and the judicial arm of the Gambia, must take note. They must take notice of what is going on in the Gambia, because it is a slow spark to a burning revolution in that country. You can see the hunger, the quest for our state institutions to act in a manner that is befitting, in a manner that would recognize and respect the dignity of every individual that goes through these institutions, be it in our court system or outside our court system, be it in our judicial system or outside the judicial system, be it in the overall dispensation of justice and in the justice delivery system of the country. There is a call. There is a call for honesty, a call for an impartial dispensation of justice, a call for fair hearing in a very timely and effective manner. For if you don't give an accused person, you don't avail them timely hearing, you have actually just robbed them of their fundamental human rights to freedom and have condemned them into probably an eternal damnation. There's a saying that justice delayed is justice denied. If you delay justice dispensation, you have invariably denied justice to the party that is suffering the most. And in this instance, it is the accused person who has been behind bars going close to 2 years now. And remember, we are not even calculating or adding into this time the time he had already spent behind bars before he was granted bail, both police bail and court bail, and eventually when the Court of Appeal revoked his bail. So honestly speaking, it would take a disingenuous government, it would take an ineffective government, it will take a government that has no business to be in power to ignore what is happening in the Gambia with regards to this matter. The executive, the judiciary, the legislature, they should all be on guard and pay attention to what is going on. And in their respective field and in their respective domain, should do everything that they possibly can to ensure that a situation of such nature does not occur again in the Gambia and within our justice delivery system. They cannot ignore. The Attorney General and Minister of Justice cannot continue to ignore what is going on. If he does that, it is a deliberate act on his part. He cannot begin to say that he is not seeing and knowing and understanding what is going on. The Chief Justice cannot in any way say that he is not seeing or is not aware of what is going on. And of course, the head of state, President Barrow, cannot possibly say that he is not aware of what is going on, nor can he ignore what is going on. It is a revolution that is being born in that country. People are not calling, or people are not saying, at least 90% of the people that I've spoken to, they are not saying free Bob because they want to say that Bob is not guilty. No, that is not what they're calling for. And it is disingenuous, it is bad, it is false if anyone tries to run away with that premise. The reason why people are calling, and the reason why the slogan Free Bob is gaining momentum, is because people feel that 2 years being in jail in a matter where the judge, the presiding judge over this matter, has adjourned this case up to 33 times when we last counted, that cannot be a fair dispensation of justice. In fact, I don't understand how a human being that is employed, you've got your TOR, you're working, you're earning salary every month, you're paid to work, you're paid to preside over a matter that is before you, you understand the principles of law, you understand the law, you understand what it means by effective and timely and transparent dispensation of justice, and yet still you can adjourn a matter 33 bloody times. And not only that, the excuses, some of the excuses for adjourning this matter, for not coming to court, are so flimsy. You adjourn a matter because your driver did not show up. A high court judge, a judge vested with such responsibility, the life, freedom of an individual is in the balance in your hands. And you don't come to court because your driver did not show up in court. It is pathetic. It is bad work ethics. And this is what we are saying, and this is what we are calling for. You can fault us for all you want, but you can't fault us for saying the absolute honest truth. A boy who, according to law, likely might be innocent, is kept in remand in Mile 2 Central Prisons, one of the worst prisons on earth. It has been acknowledged through the TRRC proceedings and recommendations that Mile 2 is not fit for purpose. It's not fit for human habitation. It has been mentioned in human rights reports. It has been highlighted by Amnesty International. So what I'm saying is not anything new. And you can have a person, an accused person, who eventually, we don't know, might be declared innocent, but have spent 2 years in court. And I can assure you that if such unprecedented support has not occurred, that judge would have continued to adjourn this matter. This case would have continued to drag on, just like other cases have dragged on before our courts, where people are kept in remand, accused persons are kept in remand for close to 6, 7, 8 years. They are in remand. How? How can this possibly go on? The issue of Bob has caught national attention. But can you imagine the very many individuals that are not like Bob? They don't have a Melville to speak for them. They don't have an Ajifanta to speak for them. They don't have a Mama Sally to speak for them. They don't have a Kex reporting. They don't have people. They don't have the Omar Wali. Can you imagine those innocent people, individuals who are continuing to languish in remand, languish in jail because you have a high court judge, a sitting high court judge that feels that in his own wisdom, he can decide to adjourn a matter in court before him for 33 times. 33 adjournment at his own instance. We are not even mentioning the times when the adjournment were at the instance of the state prosecutors. We are dealing solely with the adjournment of this particular judge. In fact, I don't understand how this particular judge, in all honesty and sincerity, can continue to preside over such a matter. So, really, this is a test case. The Gambia's justice delivery system is being showcased to the world for how ineffective it is, how biased it can be, how unfair it can be to accused persons and both the victims. And if attention and due regard is not given, I'm telling you, and you can mark my words, it is the start of a revolution that would see a lot of heads roll in that country. Because there's no way you're going to stop the amount of people that you saw in that courthouse, in that court vicinity, in that courtyard today. You can't lock them all up. You can't arrest them all. You can't prevent all of them from entering the court premises. The court is a public space. The hearing is a public hearing. It is every individual's right to attend the court hearing. It is high time that the stakeholders understand and know that an effective dispensation of justice is tantamount to respecting and having due regard for the rule of law, and for respecting and having due regard for the fundamental human rights of the accused person and the victim in this matter, because both of them have rights, and rights which must be respected at all times and at all costs. Now, I want to talk about today's proceedings. But before I do, I posted this on my Facebook. And I'm going to read the ruling of the court with regards the issue of DNA testing. He says, between the state and Babukar Keita, court ruling, dated Wednesday, 13 July 2022, before Honorable Justice M.S.M. Jallo Esquire. The Honorable Court adopts the Deputy Director of Civil Litigation's submissions, arguments, and points of law, subjecting the accused person to the extraction of a DNA sample from him as its own, and the state's compliance with the execution of the court's order of 7th July 20 22, requiring the accused person, the demised toddler, Muhammad and Pamodu Jom, to be subjected to DNA samples being extracted from them, is noteworthy for guaranteeing all constitutional rights of the accused and the other two persons being subjected to the extraction of DNA samples, extractions pursuant to Section 223 of the 1997 Gambian Constitutional. I am reading the order as it is. I am not correcting anything. The order says, pursuant to Section 23 of the 1997 Gambian Constitutional. I don't know what that means, but that is what the order says. And I'm reading the order as it is. It is not my business to correct a High Court's order. Now, the Honorable Court says that it is adopting, in its ruling, it is adopting the submissions of the Deputy Director of Civil Litigation. This is problematic in the first place because why? What is so special? This is a contentious matter. What is so special about the Director or the Deputy Director of Civil Litigation or any other state council in a matter of such nature that the presiding judge would feel and believe that you should adopt and accept hook, line, and sinker the submissions of the state council, of the state? On what grounds? In fact, if I refer you back to the Court of Appeal judgment where the bail of Bob Keita was revoked by the Court of Appeal, one of the main substantive issues that came out of that ruling was this very same mistake that the Court of Appeal pointed out, where the presiding judge accepted hook, line, and sinker the adoption of the submission of one party. The order further went on to say that it mentions that and the state's compliance with the execution of the court order of the 7th of July. This is not true. That is false. The state, in executing whatever it was that it did to collect the samples, was not done pursuant to the order of the 7th of July. Because remember, the DNA sample was clearly taken on the 4th of July. And it was marked clearly, if you look at the video that is being shown on social media, it was clearly marked the 4th of July. By the 7th of July, when the court made this order, the child was already in Senegal. And in fact, the state council in this matter did inform the court on the 7th of July that the child was ill, the child was already out of the country, the child was unconscious, and the child was in Senegal. Therefore, this order is problematic and does not reflect the reality and truth of what transpired both in and outside of the court, because when the state was taking the blood sample, or actually supervising the taking of that blood sample, there was no court order that the state was being compliant to. So this order of the 13th is problematic in nature because it does not reflect the reality of this matter. Thirdly, the other point is aside of the fact that the state was not working in compliance to an order, because you cannot comply to an order that did not exist. On the 4th of July 2022, the court had not given an order. So how can the state be compliant to an order that did not exist? This is not known to law. It is not known to logic. It is not known to common sense. And that is the truth. You might not like what I say, but it is the absolute truth. Now, the other part that is very problematic in this matter is where the same order states, and I read, and the state compliance with the execution of the court's order of the 7th of July 2022, requiring the accused person, the demised toddler Mohammed and Pamunujam, to be subjected to DNA samples being extracted from them, is noteworthy for guaranteeing all constitutional rights of the accused persons. Now, the court, in its wisdom today, said that, and this was after the State Council had informed the court that it had actually carried out the court order by taking samples from Bob, taking samples from the boyfriend. But then, the State Council now, in court, informed the court that they will be taking blood samples, or, and I want you to pay particular attention to this, they would be taking blood samples or any other biological sample from baby Mohammed. Now listen, and if you listen to my last live video, I did say that as far as I was concerned, all the judge was supposed to have done was to make an order for DNA testing. And that order should have been directed to an independent body to conduct and or supervise the DNA testing. But again, what was problematic in that order was the fact that the judge, again in his wisdom, decided to prescribe the manner by which the DNA testing must be conducted. And remember, the judge has no scientific background. He is neither a biologist nor a lab technician. So therefore, what the judge did was to give an order asking for blood samples to be taken from baby Muhammad, from the accused person, and from the boyfriend. So now, looking at that order, the judge has already departed from asking for DNA testing and now was prescribing the manner by which that DNA testing must be conducted. So therefore, now that you have baby Muhammad has died, it's obviously going to be very problematic to carry out the order of the court by taking blood samples from a baby that has died, a corpse that has probably been refrigerated for over a week. There is no way you can get blood samples from that child after being refrigerated for a week after dying. So you see how the court order now becomes problematic, because the judge did not stop at DNA testing, but the judge decided to prescribe the manner and way by which the DNA testing must be conducted and done. So now that a natural occurrence, a natural phenomena has occurred, where DNA testing cannot be conducted by extracting blood samples, that order is incapable of being fulfilled or complied with. And this is the basis. This is the basis of the Court of Appeal application that the defense has made. The substantive reasoning of the appeal of the defense is that the court order from the High Court for DNA testing should be set aside. And the reason why they're calling for it to be set aside, because the order is incapable of being fulfilled, because the manner by which the DNA testing must be conducted, prescribed in the order, cannot be fulfilled by virtue of the manner and way by which it was prescribed in the said order. So what the funny thing that happened, or the interesting thing that happened in court today, is that when the state who made the application for DNA testing, you see, the order for DNA testing was done at the instance of the state. When I say in law, when you say the instance of the state, it means it was the state that asked for that order. So that order was granted. It was an application made by the state, and it was granted. So therefore, the particular order was in pursuant to an application made by the state for DNA testing to be conducted. Now, because the state are now aware that the baby has died and that there is great potentials that the DNA, the blood sample that was taken from the child before the order of the court will be rejected by the Court of Appeal, what the state did today in court was to inform the judge that they are ready to comply with the said order when the baby comes, when the dead body of baby Muhammad arrives in the Gambia. But in a very clever and subtle way, instead of telling the court that they would stick to the order which has already laid the prescribed manner by which the blood sample, or by which the DNA test must be conducted, which is the extraction of blood from the parties concerned. Now, in a very clever way in court today, told the judge that they are ready to comply with the order. But rather than restrict themselves to blood samples, they went on to say that yes, when the body comes, we will take blood samples or any other biological sample. Any other biological sample. What the state was doing was circumventing the order of the court, which specifically says and addresses the issue of blood extraction. And the judge, in his own wisdom yet again, said to the state council, by way of a ruling, that yes, it is perfect. You can go ahead, take blood samples, or take whatever biological samples in conformity to the order that I have made. But we all know that is false, that is not true, that is not right, because there is no order that mentions mentions anything other than a blood sample being extracted. So what it means is that the state was asking the court to vary its order. What it means in law when you say to vary its order was to change the order. But then in law and in procedure, the state cannot just come to court and ask the court to change its order. The state cannot just come to court and ask the court to vary its order. The state must come to the court formally. They should make a formal application, just as they made a formal application to ask for DNA testing. The state should come formally to the court and ask that the court vary the order. And in varying the said order of the court, the state must show reasons to that court why the court should vary its order. And it is in that instance, for example, that the state would have said, well, the baby is dead now. We still don't have a body. It's been over a week. We assume the body has been embalmed or the body is refrigerated. Therefore, when the body comes to the Gambia, we are incapable of adhering to the court order, of complying to the court order by virtue of that order and its prescription, its prescribed manner of conducting the DNA test, which is the extraction of blood sample, because it would be impossible or maybe absolutely difficult to extract blood from a child who's been dead for over a week. Those should have been the reasons in that application. The defense would be given an opportunity to respond to that application, and then the judge can make an order where the judge can now vary its own order, where it will add to the blood sample being taken. It can then now add all other biological samples. So in an unprecedented move in court today, the state has clandestinely asked that the order be varied, and now the judge has handed it over to them by saying, yes, go and get a biological sample. But what the court has done now is a great travesty against the defense. Because what the court has done now, by adding biological samples to blood extraction, it has defeated the purpose of the defense application before the Court of Appeal, because the Court of Appeal application by the defense was to say that they cannot, that the order of the court should be set aside because it cannot be met. It cannot be complied to. So it means both the state councils and the court have shortchanged the defense and have rendered the application of the defense at the Court of Appeal redundant, basically. The question now that everybody should ask is why one, the state will not come out formally to make an application formally to the court to ask that its orders be varied. Or you cannot even blame the state. You can blame the state half and half. They just, as they say in Wolof, lambatuing, trying their chances. But why would the court accept that is something that I don't understand, is something that people will not understand. So I'm trying to go over the proceedings of the court today. Now, when the defense lawyer objected, the defense did object. L.S. Camara objected. L.S. Camara objected with all his might in court. and said that the state must come formally, an application seeking the court to vary its orders must emanate from the state. The judge shut Ellis up and told Ellis, and this is, in fact, I have the recording of what transpired in court, and I'm going to see how this particular part could be posted on my Facebook for people to listen. And for me, as a lawyer, I do not believe that I can ever practice in the Gambia. Now I know that, and I have accepted it, and I've told few of my family members that I can never practice in the Gambia. After listening to what the presiding judge in this matter said, I can never ever practice in the Gambia. It is absolutely not for me. Because what would have happened if I was in court was that I would have challenged that judge in such a manner that he would cite me for contempt and take me to jail. But there was no way I was going to let it slide. Absolutely not. Absolutely not. There was no way I could let it slide. Where the judge now turned to Ellis and told Ellis, and this is where Ellis raised the issue. Ellis raised the issue asking, how was it possible for the judge, for the court, to say that it has satisfied itself in the way and manner that the blood samples were taken, when there was nothing absolutely before the court? Nothing. There is nothing before the court. Nothing. There is no medical report with a little stamp or a small letterhead that the state had tendered to say that, okay, the blood samples were taken, this is how it was done, this is the medical practitioner that supervised it, or this is the lab technician that documented. There was absolutely nothing before the court except what the state council told the court. Nothing. Dara, absolutely nothing. There was no legal expert that was called by the state, by which evidence was tendered before the court, where the judge would say that, okay, I satisfy myself because this is a legal expert in this field of DNA testing, or this is a lab technician. Nothing was before the court except what the state council said in court. And the judge said that he was satisfied with what the state council said because the state council is an officer of the court. Mantela Waru. He said, again I will repeat, that he is satisfied. He is satisfied because, how do I want this Olaf? I'm going to say this in Wolof. Mom dafa satisfy ne luko state bi wax lolu mo am. Mom dafa gom lu state bi wax. Lu lawyer bi joge si state bi mu wax lolu moy lu am. Mom lolu la gom parce que state bi, lawyer state bi, officer of the court la, du federal court bi, du wax court bi lu amut. So mom lu ko lawyer, lu ko state bi wax rek, mom lolu la mo jel. Allahu Akbar. I am shocked. Shocking. Because what it means, it is scary. It is absolutely scary. And what is more scary about this and frightening is that the judge in presiding in such a very contentious matter, in a matter where the state has got vested interest, In a matter where if the state did not want to secure a conviction for Bob, they would not have filed an indictment in the first place. They would never have brought him to court. So obviously the state wants to secure a conviction for Bob. And you are saying in that case, whatever the state tells you, that is what you will take as gospel because the state counsel is an officer of the court? Then what the hell are we in court for? Just take what the state has said. They said, as far as they're concerned, Bob is guilty. They brought him to court. Just take that, close the case, right, and sentence Bob. Everything mujhe. That. I mean, to be honest, just do that. If everything the state tells you is what you're going to take as gospel, there's no need for us to be there. There's no need for people to even bring any action against the state anymore because the state as such, godly, righteous, supernatural, no mistake, self-righteous entity that whatever they say is what is gospel. Is L.S. Camara a seasoned lawyer, not an officer of the state, of the court? Is L.S. Camara, the defense lawyer, not an officer of the court? Would you just take anything that L.S. comes and says in court as gospel? Would you? What law was that premised on, that ruling? What inspired that law? Where did the presiding judge take such an inspiration from? Where? Where? It is not known. It is not known to law. It is not known to procedure. It is not known to legal understanding. It is not known to legal knowledge. It is not known to common sense. It is not known to logic. Because if everything that the state tells you is going to be adopted and accepted as gospel, then you might as well sentence the guy right now and end the trial. Because the state is there to tell you that he is guilty. Believe them once and for all right now. For heaven's sake, how can you expect such a guy to continue to have fair hearing and a fair dispensation of justice under this same presiding judge? And I have said it and I have made my point known that the judge has to recuse himself from this matter. He has already compromised himself in this matter, and that is the absolute truth. If you want justice for Bob, that judge must recuse himself from this matter. I will go on to read a particular statement in this ruling. So, what the application that Ellis filed is for an appeal of the court order for DNA to be set aside and or a stay of execution of the said order. A stay of execution of the said order. What that means is that the order was made. Now, the defense team, the defense lawyer for Bob, said to the court, rather than even trying to change your order, or even vary your order in a way and manner that you shouldn't do, wait, allow us to put a motion for stay of execution of the order, pending the determination of the court, the appeal that has been filed at the Court of Appeal. I'm trying to see if I can explain this in clear language and take the technicalities out of it. So what it means is that, you know, an order was made from the lower court for DNA. And then Ellis has now appealed. So appeal as in like he's gone to court to say, no, we don't agree to this order. The Court of Appeal, which is a higher court, can you set this order aside? Now, ordinarily what you will do when you have made an appeal, because this order, until it is set aside by the Court of Appeal, is still a subsisting order, meaning the order is still valid, you will then make an application to that court for a stay of execution of the order, pending the determination of the case in the Court of Appeal. So what it would mean is like, okay, you've given this order, judge, but please, can you just hold on? Let us wait and see if the big brother court, which is the Court of Appeal, will either say, oh no, you were right, let them carry on, or no, you were wrong, this order is not right. Because if you let them carry on now and be doing everything, and then the Court of Appeal say that this order is not right, it would have been time wasted. You would have done the things you are not supposed to do. But guess what? Ellis did not, the defense lawyer did not even make the application to the court. And in this ruling, the judge went on to say that the stay of execution, I want you guys to listen to this. Stay of execution, even if applied for, would not be granted if they are purposely requested to waste the court's time. So basically what the judge have done now is to tell Ellis in a very nice and diplomatic way that don't apply for a stay of execution, because even if you do apply for a stay of execution, I will not grant it, because as far as I'm concerned, you are doing it to waste the court's time. That is a premature ruling into an application that is not even before the face of the court. It means you're already prejudicial to that application, because that application has not even come before you, and you have already ruled, put it conspicuously in your order to say that when it comes, you're going to reject it. How is that fair on the accused person? And then some people are blaming the defense, but then in such an instance, the hands of the defense is tied. You saw a judge that specifically stated, that he is satisfied in the way and manner a particular blood sample was done, when he does not know what happened. There's nothing before him to tell him how it happened. He said he's satisfied with it. You have a judge now who is saying that even if the defense make an application, it is the right of the defense to make an application. It is the right of the defense to make an application in court. It is normal court procedure. It is their right. But if you've taken away that right from the defense by coming up with some nice old line of, this is like a threat. This is I would call this a judicial threat. This is a judicial threat. Because you're threatening the accused person from filing an appeal or asking for a stay of execution, which is his fundamental right so to do. It's his fundamental right so to do. If you look at number 3 of the said ruling, it says, the Honorable Court is well satisfied with the extracted DNA sample of the demised toddler Muhammad, who had a blood sample drawn from him at the Edward Francis Small Teaching Hospital whilst in coma before being transported to failed treatment in Senegal. In fact, I don't know what is failed treatment in Senegal. How can the Honorable Court be satisfied with the extraction of the DNA sample of the demised toddler at the Edward Francis Small Teaching Hospital when you don't have a single document before you in that court that bears the seal and or stamp of the Edward Francis Small Hospital? You are only satisfied because a state council told you so. A state council that has vested interest in seeing that Bob is convicted beyond all measures. In fact, apart from the video we saw on social media, the state council did not even tell the court when that blood sample was extracted. The state council did not tell the court who supervised the extraction of that blood sample. The state council did not tell the court where that blood sample is being kept all this while, under whose supervision. The state did not tell the court that, yet the court says in this ruling that it is well satisfied. But it didn't even say I'm satisfied. It said it is well satisfied. You would have thought that it was the director of medical services that led expert with testimony in court to tell him about the manner and way by which these blood samples were extracted, where it's kept, how safe it is, who was present. Nothing. The judge knows nothing about these things. And this is a fact. It's a fact. It is only what the state council said to him. And he said he is satisfied. How can he be satisfied? You cannot be satisfied with something you don't know. You cannot be satisfied with something you have not seen. You cannot be satisfied with something that is not before you. Lolo, it is not known in law. But again, when you listen to what he said in court today, that he will believe whatever the state council says to him because the state council is an officer of the court, you then begin to understand what inspired such a ruling. But then what it means is that Bob has no line of defense in that court. Because anything that the defense object to, if the state says something, he has already said that whatever the state says, that's what he will believe. So what's the point of being in that court? What's the point of him presiding over that matter? And nobody should talk about it. Nobody should say anything. Everybody should keep quiet. Me, I will talk about it. And I will say it. I will say it. I wish it was winter, sir, because now it's very hot. So when I talk, I get tired. But if it was winter, I can do this for 12 hours non-stop. But right now, I'm very, very, very hot. I want to go on and I want to stop because it's so hot. But it's just that these things have to be said. People have to know. So guess what now? Listen. Let me tell you guys the most interesting part. And that question is what I see everybody asking. Why was the matter adjourned for Thursday? You know why the matter was adjourned for Thursday? I'll tell you. The matter was adjourned for Thursday so that they could hear the application, because Ellis made an application in court, which is a response to the motion filed by the state. No, I'm wrong. No, that was not in response. It was the state. It's the state that has asked that they be given 48 hours to respond. And now the state has also asked that they want to include the mother of baby Muhammad in the DNA testing. But the Ellis did not object to that. So of course that is on. But what I don't understand now is that the adjournment for Thursday, in all indication, is useless. It's absolutely useless. Because the judge has already preempted. He has already said, he's preempted what Ellis would do. He has already taken his position on what he would do. So me, I don't see the point of the Thursday hearing. Because he has already said what he's going to do. He's already said it. He's already made his position known in that matter. So Sunday, Thursday, maybe Thursday in retrospect, I think is another blessing, because what people saw today in that courthouse, it's going to be 10 times more on Thursday. It's going to be 10 times more on Thursday. Because this is going to be a revolution. A revolution for the fair dispensation of justice. Trust me. And if it means for us to start contributing to get people to have water in this heat when they're in that court, to get them probably sandwiches or whatever, we're going to do it. We're going to do it. Trust me, we're going to do it. We're going to ensure that we know how hot it is. I mean, I'm in England, I'm dying right now. We're going to make sure you have cold bottles of water. Maybe sandwiches. I don't know how they're going to do it. I'm going to work with Ajifanta and the ladies and what's her name? Amina Jan and Mama Sally. And we're going to ensure that people are refreshed. But people will not relent, because this trend will not continue. This trend is not going to continue. This is going to stop. It's going to stop. Bob has no place and no reason to be in mile 2 right now when they're struggling to do a DNA testing. That should have been what should have taken Bob to remand. The result of DNA testing should have been the basis of charging or not charging Bob. That should have been the basis. It is not now that the guy is in mile 2 for 2 years and then suddenly it becomes the basis of the prosecution's case. But that is what Gambians were used to. That is what we were used to. That is what is being done. You have officers in the state law office, and me, I will always mention this. I have not yet mentioned her name, and it is deliberate. Because me, my fight is my fight, and I take it differently, and I fight my battles differently, and I fight them forever. But there is one individual in the State Department, the State Law Office, in the Ministry of Justice, that is responsible for all of this. All of this that you're seeing, one sole individual in that office who thinks and believes she owns and runs that office. Who will write legal opinion that are not based on law, that are not based on the facts before her. Who will decide arbitrarily on her own accord that I will charge Bob, I will let the boyfriend go. One law official in that office. But when the time comes, we will address that issue. I have my reasons why I cannot address that issue. But we will. Because she tried it with me. She did it to me. And I have all the evidences before me. I have my testimony, I have my witness statement that I wrote. I know what I wrote. So when a state law officer sits in the confines of her air-conditioned office and writes a bunch of garbage and nonsense and decides to lie against me, to say that I have accepted to do something which I have not accepted, I will confront that individual in every way and manner that I know possible under the earth. But I'm just waiting for the right time. This is about Bob. This is about Bob, so we're going to make it about Bob. It's not about Melville. But when that time comes, I will expose that individual purposely, and I will see what that individual can do. Because I will expose her lies. I will expose her lies. If you want to be an activist, go and be an activist. The state law office is not a place for an activist. Your activism, keep it at home. Keep it in your private chamber. When you are in the state law office, you are there to dispense justice fairly, in a transparent way, in an equitable way, in a fair and just way. You want to be an activist? Take your activism to your backyard and stay there with it. Don't hide behind the resources of the state. Don't hide behind the resources of the state to propagate your false agenda of activism against innocent men, against men that you feel you're threatened by, against men that you are jealous of, against people who you do not even have an idea or don't know how they work so hard to get to where they are. If you have your feminist ideologies, you have your activism ideologies, I respect it. I respect it. But take it out of your professional work. It has no business and no place there. A state council cannot lie in a legal opinion. A state council cannot lie in a legal opinion. That is criminal. It is criminal for a state council to lie in a legal opinion. A legal opinion, when a state council or anybody is doing a legal opinion, it's an analysis between the law and the facts before you as presented to you. You cannot add to the facts. You cannot minus to the facts. You stick to the facts. Analyze the law with the facts before you. But if you lie in that legal opinion, you are dubious. You're not fit to be there, and you're a criminal. You're a criminal. And for those of you who do not know, when you meet Ellis Camara in court, on Thursday, ask him, he will tell you. Because I have put the Attorney General on notice for this. I have written to the Attorney General 4 times. 4 times. And my language was clear to the Attorney General. I told the Attorney General that the State Council that wrote that legal opinion lied against me. And that's what I said. She lied against me. I'll tell you something you people don't know about Bob Keita today. I didn't want to say this, but I'll tell you today. When I went to the Gambia in 2020, it was the first time I met Bob Keita. And again, like my issue, I traveled to the Gambia on my own accord because I always believed in my undiluted innocence. In fact, those that have been following me would tell that when Haruna Drame came to England and interviewed me, he asked me a question. He said, Melville, would you ever go to Gambia? And I said to him, why won't I go to Gambia? He said, because it is not safe. The recording is there. He said, because they've written that, that you're wanted. They have a bench warrant for your arrest and everything. I said to Haruna, I will go to the Gambia because I have done nobody any wrong. And indeed, I bought my ticket and I traveled and I went to Gambia. When I arrived in the Gambia, I went on my Facebook and I wrote it there, and those of you that have followed me and on my Facebook, it is there. It is conspicuously stated that I have arrived in the Gambia. I will subject myself to the authorities that are vested with the power of investigation in the Gambia. And that is exactly what I did. When I was done with what I was doing, And when I was informed that Batambedu was trying to play hanky-panky with me, when the police failed to provide me with the police report that was conducted and done on my person, I bought my ticket and I left because I have better things to do. I am a lawyer. I understand the judicial system. I understand the judicial loopholes. And I was not going to make myself a sacrificial lamb for any idiot where I'll be locked up in remand. And every day, today, tomorrow, they'll be telling me I'm going to court. The judge is not here. I'ma pass, I'ma essence, so my driver be known. I don't have that time and I'm not stupid. So I did what I was supposed to do. And I left. The rest is history. But then, I wanted to tell you guys, as I mentioned, I'm going to say something about Bob that people don't know. So when I went to the Gambia in 2020, it was the first time I met Bob. So Bob, Sabali, Omar Wali, Idrissa, you name it, all of them came over to the house. I cooked. We had a meal together. Ajifanta was there. It was fun. It was a fun day. We had so much fun together that day. And I called Bob aside. And I said to Bob, I said, Bob, I said, I am a lawyer. I said, you know why I'm in Gambia? I said, I am in Gambia because I know absolutely that if I never come to Gambia, it would be absolutely impossible for the police to finish and conclude their investigations on me, because it is very difficult for the police or whoever is investigating to conclude their investigation when they have not heard from the accused person. I said, because I don't want this to be on my head, I don't want it to follow me all the days of my life, I decided that I was going to Gambia, I was going to face the police, all the investigators, and give them my own part of the story. That way they will be able to conclude their investigation. And that's exactly what I did. That's exactly what I did. Now, I called Bob and I said to him, Bob, I said to him, the way I'm seeing this matter, and you have just told me that you have an American visa, you've told me you've got a British visa, I said you don't have any business sitting in the Gambia. You don't have to prove shit to no one. That's what I told him. I said you have given your statement, you have done what you're supposed to do. The baby has been born. They have not called or asked that you conduct or you do a DNA test. I said to him, you are the accused person. It is not your business to go and force the complainant to conduct a DNA test. And there's one thing that I want people to understand and I want people to get. And that is, under our criminal law, under the law, a person who has been accused does not have any responsibility to prove his guilt. In fact, that person can go to court and remain silent throughout the entire proceedings. The responsibility doesn't shift. It's squarely is on those that have accused him to prove a case of rape against Bob beyond a shadow of doubt. So those of you, I had somebody called on the Mama Linger show yesterday to say that Bob should call for a DNA, or if I was me. All of those things are utter rubbish. They are rubbish. Bob has been accused. It is for his accusers to prove their case beyond a shadow of doubt. It is not for Bob to prove his innocence. It is not for Bob to prove his innocence. It is for that reason that they would tell you in England, in America, they're quick to tell you that you have the right to remain silent, for anything you say can be used against you in a court of law. You have a right to remain silent. It is your inherent constitutional right. You need not prove nothing. A woman comes out to say that you raped them, the responsibility relies on that woman to prove that you raped them. It is not for you to prove that you did not rape that woman. That is the law. Anybody that tells you anything outside that is lying to you. Bob does not have to prove his case in court. It is for the prosecution. It is for the state council. It is for the alleged victim to prove their case beyond a shadow of doubt in court and to fulfill all the specific ingredients, the layers of ingredient that is necessary to prove their case beyond a shadow of doubt. And the law says, beyond a shadow of doubt. That is the threshold. For even when there is one single doubt, that judge is bound to acquit. That is what the law is. But in the Gambia, it is practiced otherwise, and we know that. But that is the law. Even if there's a shadow of doubt, even if there's one speck of doubt, and I want you all to go and conduct your research, look into that. It says, without a shadow of doubt. Beyond all reasonable doubt. If there is one speck of doubt, if there is one speck of doubt, that judge is bound. His hands are tied by the law to acquit and discharge that individual, that accused person. So all of you telling me, all of you telling people that, oh, Bob should call for DNA test, it is utter rubbish. That is not what Bob should do. That is not the business of Bob. It is not the business of Bob to call for DNA testing. It is not the business of Bob to tell the state how they should prosecute. It is not the business of Bob to tell the state what evidence they should lead against him to secure a conviction. Bob has a right not to say a word. The responsibility has not shifted on him to prove his innocence. I will go back to my story. So I said to Bob, I said, you have a visa. I said, if these people are after you like you have explained to me, whether they are after you because you are part of the NPP and it's a political thing, whether it is your wife, your ex-wife that is after you and his family and her family, whether it is people within the state law office that are conspiring against you, I am telling you, Bob, that they can use the loophole in the judicial system. They can use a very weak and ineffective judicial system to go after you, and you will spend at least good part of your life in jail, in remand, waiting for a matter that will be adjourned every other week. This is what I said to him. I said, buy your ticket and leave. I even said to him at the time, I said, if you don't have money to buy your ticket, I'll buy it. Leave. You guys want to know what was Bob's reply? He said to me, Mel, he said, if I leave, they will say that I ran away. He said, if I leave, they will say I ran away. He says, and if I leave, it would feel as if I did something bad and I did something wrong. He said, Mel, I know I'm innocent, so I am going to stay and I'm going to clear my name. This is what he said to me. So you tell me, you self-righteous propagandist, you tell me a person that is innocent, a person that is guilty will have a US visa in his passport, will have a Schengen visa in his passport. And then you decide to stay for a crime that you know you committed. Who does that? Who does that? In fact, when the bail issue for Bob came in court, that was the first time that the court knew he had a valid United States visa. Because in his bail application, he decided, thinking that he was dealing with a proper, effective system, he decided to say that I have a valid visa, I'm leaving it with the court, I'm not going anywhere. You know what happened? All these activists that feel they have connection and they know people in high places and people in power, they ran to the American embassy, and within a moment or two, Bob sent me an email where the American embassy cancelled his visa. As far as I'm concerned, it means the American embassy had taken a position on this matter already. They cancelled his visa without even giving or availing Bob the assumption of innocence. But today, and it is so sad because when I spoke to him a few months after, and after his brother died, and after his business was struggling, in fact, I don't know if I should say this publicly, but probably I should, because I see a lot of people, you know, wanting to say stuff. If you speak to Bob, he would tell you that I was helping him to sustain his business activities. I was. If you talk to Nene Frida, he will tell you that his first Tobaski when he was behind bars, I bought ram for his mom. I took stuff for his mom. But in fact, these things are useless. I don't even have to say it. But I mean, I saw some comments today, and some people think, oh, they've just jumped on the bandwagon. No, that's not it. Bob will tell you. He knows how he gets his credit, how he does his business. He will tell you if you ask him. And he said to me, Mel, you know what? I said, what? He said, my biggest regret in this life is not listening to you. He said, my biggest regret in this life is not listening to you. He says, because you told me, Mel, you told me you understand the judicial system. You told me how I can be behind bars for so long. He said, Mel, I never believed that this matter would take this long. He said, I never believed in my life that this matter will take this long. But again, it's too late. It's too late. Because even though people are calling free Bob, free Bob, free Bob, I'm sorry. I'm sorry. Except this matter is concluded, except the state decides to withdraw, Except the state decides to file a nulli, Bob is going to be there. He is going to be there. You're going to shout, free Bob, free Bob, free Bob. From now till thy kingdom come, Bob will still be there. Because that is the loophole we have within our justice delivery system. You have instances where you will go to court in a criminal matter. Somebody is behind bars. The judge will tell you that they have just received the file before them. They have to familiarize themselves with the case. A state counsel will tell you that some other state counsel was handling the matter. They need time. A state counsel will come to court, and being all fair, the defense will do that as well. They will come to court. They will tell you they have matter in a superior court. They will tell you, oh, I'm in the Court of Appeal, or I'm in the Supreme Court. Yet still that accused person will continue to languish behind jail. And it is for that reason, that is why you shouldn't have fraudulent, and I call it fraudulent, criminal indictment against a person without any evidence. And this is why I keep saying that we need an effective pre-trial judicial system in the Gambia. You need an effective pre-trial judicial system in the Gambia, where before the police can charge a person, on a crime of rape or any crime under the Sexual Offences Act, a crime of serious nature, they would need to go before a pre-trial judge and satisfy the pre-trial judge that they have prima facie evidence against this individual before they could take leave of that court to charge, or before the court can grant them leave to charge. And I believe the same thing should apply at the Ministry of Justice. It is not just because one state council that you have a beef with outside, or just because you had an exchange with one state council, they don't like you. So just because something goes before them, they will write a legal opinion and say you must be charged. And because it comes from them, it is gospel. Then who is refereeing the referee? Who is policing the police? Who is policing the police? Of course, you should have the director of the DPP. You should have the Attorney General supervising these things. But we all know that that is not how it is done. We all know that is not how it is done. So arbitrarily, somebody can sit at the Ministry of Justice. They don't like Melville. Has been having a beef with Melville for as long as she can remember. The police brings a file at the Ministry of Justice asking for legal opinion. They would write a legal opinion to the effect that go and charge Melville. Without any iota of evidence, without a shred of evidence in front of them to warrant a charge for Melville. By law, the state law office should never file an indictment in a matter where they know they cannot secure a conviction. And this takes me to the police. And I pray that somebody will send my message to the Inspector General of Police or to any senior police officers concerned. And I will say it again, and I've said it before. There is no law known in the Gambia that mandates the police to take a case file where they have been the lead investigators to the Ministry of Justice asking them for legal advice. None. There is no law. Back in the days, the reason for that tradition or the reason for that practice was because the police did not have the legal expertise and knowledge to advise themselves legally before charging a person. So therefore, the police relied on the state law office to give them legal advice. But that is no more. The police have lawyers. The police have lawyers. The police have experts in human rights law. The police are vested with a whole department of boasting of the finest lawyers you can find in the jurisdiction of the Gambia. Highly trained, highly professional. So why would the police, with their legal expertise, legal knowledge, coupled with their knowledge and expertise of investigation, you go and send your case file for one little state council to sit in a corner and write a legal opinion on you and then lie on the legal opinion and change the facts and put in that opinion and say things that is not in the facts that the accused person never said? Why will you do that? When will the police stand their ground and boast and show of what they have? The IGP, the current IGP, is a seasoned lawyer. A seasoned lawyer. The state councils are not better than the IGP. They don't have a vast legal knowledge better than the current IGP. A seasoned lawyer, an experienced police officer, a seasoned investigator. With such a huge department, with the amount of resources that the police have invested in training their police officers to become very formidable lawyers, and then you painstakingly go through an investigation, add all the drama, the pain, the resources that are needed to investigate a crime. It goes to your department for prosecution, which also boasts of lawyers. Only for you to take that case file, you send it to the Ministry of Justice, and you're asking them for legal opinion in an investigation they know nothing about except what is before them. How does that even make sense? Anyways, I cannot do the other things, so I'll leave that with the Ajifanta them and Amina Jan and Mama Sally and Ndai and everybody else that does that. But really, what I would say is that there should be an understanding between people that are going to show support for Bob and the police. The police are not your enemies. The police are your brothers and sisters who are equally sharing in this pain. Treat them with respect. Treat them with the dignity that is due them. But come out in your numbers. Come out in your numbers and show the state of Gambia that you are fed up with the status quo. Come out in your numbers and show the state that equal, honest, sincere, open, transparent justice must be delivered, and it must cut across board. The dispensation of justice must be transparent, it must be fair, it must be effective, and it must be done in a timely manner. Come out in your numbers. Let nobody fool you that you're not making an impact. You are making an impact. They know what is going on. They're seeing what is going on. And they will take action at the end. They will take action. The voice of the people will always be the voice of God. And they will listen. They will be forced to listen. Come out in your numbers. Anywhere you are in the Gambia, go out. Show support. You're not saying that Bob is innocent. You're not saying Bob is guilty. What you're saying is Bob deserves a free and just trial. What you're saying is the death of baby Mohammed must be investigated. The circumstances surrounding his death must be made known. People should know what happened. And those that are responsible should be held accountable. This is what we're calling for. This is what we're calling for, and this is what we're saying. So go out in your numbers. Go out in your numbers. Continue to call for an overhaul of the justice delivery system in the Gambia. A justice delivery system must work. It must seem to be working. And it must be fair. Do not relent. I'm telling you, do not relent. There are judges that share your pain. There are magistrates that share your pain. There are lawyers that share your pain. Doctors, engineers, nurses, midwives, police officers, soldiers, civil servants. Everybody is unanimous in this call. It is a clarion call for the true and effective dispensation of justice. Don't think you're alone. This is not about the youth. It's not about people who love Bob. It is not about people who know Bob. This is about everyone, because today it could be Bob. Yesterday it was Melville. Tomorrow it could be you. It could be you. So on that note, I wish you all the best. I've said what I've got to say. And we continue to pray that God will continue to be with Bob. God will continue to be with the accused person. And Bob will continue to be even with the family of Zainab, because I think she deserves prayers as well. There's no way humanly possible that she could be happy wherever she is. She might fake the happiness. She might act like everything is okay. She might just want to appear strong. But she must be going through a whole lot. I'm sure she never imagined that this matter would attract such unprecedented attention, both nationally and outside the country. I'm sure she never thought that her life would be dragged into this mess. She never thought or imagined that the affairs of her family would be the subject of ridicule and discussion in all quarters of the country. So she too deserves our prayers. She needs help. She needs help. What she's doing is actually a cry out for help, a cry out for love, for some people to reach out to her. That's what she's calling for. She's calling for attention. And for me, I always say my own. I will defend Bob to the very last. But I would not also allow or, how should I say, clap for or support the continued ridicule of Zainab Umbai. Whatever Zainab Umbai has done, be it right or wrong, she's got a conscience. She's got a conscience. But one thing is certain. One thing is absolutely certain. Is that there is no way you can tell me she is not going through pain. There is no way you can tell me that everything is well and okay. No. In fact, let me tell you something today. Psychologists would tell you that people that are okay will not go outside to make videos and tell you they are okay. When you are okay, you don't need to prove to people that you are okay. When you are rich and you have money, you don't need to prove to people that you are rich and you have money. You do not have to go out of your way to prove things that you know you are. So, as we remember Bob, let us remember her in our prayers. Let us continue the fight for justice for Bob. Let us continue the fight for justice for baby Muhammad. But let us not derail our focus by making Zainabu the subject of ridicule and the center of attraction or attention in this matter. I thank you all once again, and I wish you all the best. And like I said, I'm going to speak to the persons concerned and the people that are actively working on this, and we're going to find ways where we will get probably cold water, refreshments of some sort, and just get people to come out. If you don't have fares, you don't have any, just come out. Just come out and support. Tell a friend to tell a friend. Bring your banners, wear your shirts. Yes, call for a free dispensation of justice. A justice that is fair and equitable. A justice that cuts across creed, cuts across ethnicity, cuts across social status. It shouldn't matter what manner of person is being dealt with. Justice should be fair. The scales of justice should be balanced at all times. So I thank you all, and I wish you all the best, and good night. God bless.